Thank you for contacting us here on Justice on Demand. My name is Christian Pedersen, Arizona attorney. Want to talk today a little bit about what we call slip and fall injuries. Slip and fall injuries are unfortunately very common in Arizona, and as the name sort of implies, a slip and fall injury happens when you either slip or fall or trip over something and are injured, typically on someone else's property. Usually, in most slip and fall type accidents, the cause is some sort of substance on the floor. It might be water, it could be oil, it could be some cleaning product. I even had a calendar that caused a slip and fall accident. And yes, I did say a calendar. I had a client that was at a store and there was a calendar that was sealed in shrink wrap and had been on the floor for over 24 hours. The manager and store owner knew about it, never did anything to pick it up or fix it. And my client unfortunately went down a crowded aisle and slipped and fell on the calendar and injured his knee and his back. And typically these accidents happen in parking lots, from sidewalks, inside grocery stores, or sometimes even at work. And even hoses or cords or cables can cause trip and fall or slip and fall type accidents. So whenever we're dealing with any type of personal injury case, the first thing we have to look at is what we call liability. Liability just means who was at fault, who was responsible for for the condition that caused the slip and fall. Uh, because slip and fall accidents usually involve multiple people, multiple parties, they can become very complicated very quickly. For example, years ago, I had a slip and fall or trip and fall accident at a parking lot of a popular fast food restaurant. The fast food restaurant had recently had its parking lot repaved, and there was a substantial dip in the asphalt, about 2 feet long by about a foot wide or so, and maybe 6 to 8 inches deep. And as you know, when it's hot and sunny outside, and there's that matte black asphalt, um, thing imperfections in the asphalt can appear to be flatter than they really are. I had a client who dismounted from his motorcycle and fell over due to the hole and hit his head and suffered a traumatic brain injury. In that case, we first wrote a letter to the fast food restaurant saying, "Hey, this happened at your property. You're responsible." They sent a letter back to us saying, "No, we're not responsible. The general contractor who we hired was the one actually responsible for the parking lot." We then reached out to the general contractor. They said, "No, the paving company who put the asphalt down, they're the ones responsible." So then we reached out to the paving company and they said, "No, we're not responsible. It's the plumber who was responsible. They installed a pipe under the asphalt in the parking lot for the grease trap, and they're responsible, not us." And so they're all pointing the finger at each other. Nobody's willing to come forward and take responsibility. So we had to file a lawsuit and make sure that we got all of the parties in. If you miss a party to that to the lawsuit, what will usually happen is the rest of the defendants will then point the finger at somebody that you missed and say they were the ones that were responsible in an effort to try to kind of lowball and torpedo your case. Another thing that insurance companies love to do on trip and fall or slip and fall accidents is blame the victim. They will often say that, well, we're not responsible even though there was a dangerous condition at our property because your client should have seen what was going on. They should have been paying attention to where they're walking. And there is some merit to this argument, right? I mean, we do need to kind of watch where we're going, but at the same time, none of us are sitting there scanning the ground like this with blinders on. We're kind of scan generally and have our eyes kind of, closer kind of parallel to the ground versus looking down at the ground the whole time like that. A lot of times they will say that the dangerous was open and obvious and that your client should have known about it. And I'll say, well, this was your property. You were responsible for maintaining it and keeping it safe. And if you say it was open and obvious, then you should have obviously fixed it, right? This is your property. And if it's so open and obvious, why didn't you fix it? Some of the things that we have to prove in order to win your case, whenever a slip and fall accident occurs, is we have to prove that the person or company that owned the property either had control of it or owned it or renting it in some way. In addition, we have to show that a dangerous condition existed. This could be somewhat subjective as to what defines dangerous, because what can be dangerous to an adult may be very different to what can be considered dangerous to a child. It also can depend on the circumstances and the type of business or type of property that's involved. The third thing we have to show is that the company or person that owned the property and was responsible for it, they either knew about the condition or they should have known about the dangerous condition had they just done, a reasonable inspection and kind of done their job in inspecting the property. And then the last elements we have to have is someone that was, as the name implies, it's a personal injury case. You were injured and you had medical bills and suffering as a result. Now, what are some of the things that you should do immediately following a slip and fall or trip and fall type accident? Well, first, if your injuries are severe, you should call 911 and go directly to the hospital. Make sure while you're at the hospital that you talk to doctors, and if they need to do any type of scan, such as an MRI or X-ray or CT scan, that they're doing those things for you. After you're out of the hospital and able to talk more, it's a good idea to see if you can get from the property owner if there was an incident report or the names of any employees that were working there. Sometimes if there is an incident report, they may have witnesses from customers or other people who may have seen what happened. Getting their information is very important as well. If you or one of your loved ones or friends are with you, getting pictures of the condition as it existed when you fell. A lot of times companies will, when somebody gets hurt, they will then fix the issue immediately after the accident so that nobody else gets hurt, which is good, right? But then we don't have a visual representation of what happened and your perspective of the scene. Another thing to do is to make sure that you keep your clothes and shoes that you were wearing at the time of the fall. Again, insurance companies love to blame people for wearing flip-flops or things like that to, a grocery store, saying that, well, you should have wore shoes with better traction. And I'll say, well, this is Arizona. 80% of the people going to the grocery store in the summer are wearing flip-flops, and you should know that. And so you need to make sure that your store and your premises are safe for people that are wearing flip-flops, as the majority of your customers are going to be wearing flip-flops during the summer. Lastly, one thing I recommend to all of my clients, for regardless of what type of injury it is to keep a journal. Document the doctors that you went to. Document what happened immediately after the accident, how you felt, what kind of pain you're suffering, how it's affecting your what we call activities of daily living. That just simply means how much harder is it now for you to do the dishes or go to the grocery store, clean the house, fold laundry, things like that. If there's any hobbies that you can't do anymore, such as play golf or go for bike rides or go to the gym, document all of those as well. That and how that it's affected your life. If you or anybody that you know has any questions or concerns or wants to talk about a slip and fall accident, please reach out to us. Our initial consults are always 100% free. We work 100% on contingency, meaning that we don't get paid until you get paid. So you'll never receive a bill or invoice or anything from our office.